estate planning, wills, and power of attorney update. My name is Ken Vercammen, and I'm an attorney in Edison, New Jersey, and we try to help out the public by having programs throughout the year. This year is a little different because instead of having a whole 20, 30 people in my office, we have what the governor says as the permitted amount. So typically we talk about the dangers if someone does not have a will, or they they cheaped out and they had something that they did for free online. Well, if it's not done right, if it's not signed right, then the procedure to omit a will to probate becomes much more complicated. So it requires that there be all the beneficiaries sign what's called a renunciation. Now you hope that the family all works together and does stuff, but instead you want to be make things as easy as possible. So for example, in one of our matters, brother dies. That means all 7 brothers and sisters in the United States and India have to sign a renunciation. Well, if someone doesn't sign, then that means that the person who wants to become the administrator has to have the attorney prepare a complaint, order show cause, file in the county surrogate, and then has to serve everyone, and then we have to have a hearing for the judge to appoint someone to be the administrator of the estate. If everyone can agree, everyone signs a renunciation in front of an attorney, someone becomes the administrator. But by having a valid will, we skip that step. Number 2, if there's no will or the will doesn't say it, the person who becomes the administrator has to take a thing called a bond. If there's a will but it doesn't say no bond required, then the executor has to take out a bond. Bond costs about $1,000. Having a will costs less than that. So that's why when we do our documents, we make sure there's a clause that says no bond is required. Number 3, state law determines who gets your assets, not you. And many times nowadays people are deciding, you know what, do I have to leave everything equally to all my family? He goes, no, you decide who you want. If someone says, I want to leave everything to, my church, this charity, that is your right. I'd say if there's minor children, then a bald white guy in New Brunswick determines who gets custody, and it's a lot of times it's difficult to determine who's going to have custody of your kids, but it's easy to determine who you don't want to get custody. But most importantly, whenever there is no will or it wasn't done right, it often causes aggravation, stress, sometimes fights amongst the family. So when people are grieving, you don't need one more thing. I mean, if you were in a rush to go to the airport, you wouldn't want to get into your car, if you're driving and say, oh, I have to stop and get gas. Or the lights saying check engine or needs oil. So doing wills in a way has become easier after the COVID thing, because before that we would mail out a questionnaire, then we make the people fill it out by hand. It had to be by hand, and then have everyone come into the office, and we insisted they sit down with us. We wanted to talk to them personally, etc., etc. Well, when the state closed down, and even before, we started emailing the questionnaire, and he goes, you know what, type everything up and then get it back to us. And in a way, it made our life easier. So I no longer had to read Bala Subramanian's handwriting, how to spell his name, and his wife was like, Kishore, Bangalangan, and then their executor too was someone else whose name I couldn't read. It's there. So the only time there's spelling errors is when someone types their own family member's name is wrong, or they make their own mistakes. It's kind of funny because I've seen people make mistakes. So when it comes in, I do a spell check right away. So logistically, we email out the questionnaire. I look at it, I do a spell check, I call everyone, and then we're going to go into what goes into the will. So, number 1, we ask if someone is legally married. because like some of my Spanish clients, they consider someone that they've been with for 25 years their spouse, but New Jersey does not recognize common law marriage. I'd say, and then then you're gonna put down who is executor one, who is executor two. We never recommend joint executors because it's more, in a way, creating more work. The idea is have as little work as possible. See, why aren't there two governors at the same time and two mayors? They could split the work because there's gotta be one captain of the ship. And, even if they could be identical twins living together, but that means two people have to go, deal with the surrogate. Two people have to sign every check. Two people have to sign the contract with the realtor. Two people have to sign the contract for sale. Two people have to sign the addendum. Two people have to do every single thing. And I tell a lot of times people, I know better what they need than they need. When a lot of people want to read up and about stuff. I go, so you don't need. I've written a book. I read all the time. I've done your reading. When I had knee surgery, I didn't read anything all about knee surgery. I didn't want to know. I did ask the doctor one question. I'd say, have you done this type of new procedure before? And the doctor said he was a doctor for the Rutgers football team and other teams, and because I want to go to someone who dealt with athletes, not the one who does mostly Medicare people who advertises on the side of the bus. So, similar to that, I tell people, I've done the reading for you, and I've had people that there was a fellow in Edison that came in, we went over his stuff, how we can reduce taxes, etc. And he wanted to do more reading. I go, Carl, you don't need to do any reading at all. This is what I do for a living. I want to do more reading, I want, think. And then when the guy dies, 2 years later, the family asked me if I had his will. No, you want to do more reading and think about stuff. So, there's an executor one and an executor two. Okay. New Jersey, by the way, did away with the tax. Who would think about that? They did away with the tax. They did away with the New Jersey estate tax. So there still is a federal estate tax, but I know there's like a whole lot of people in my Edison Elks Club that have more than $11.5 million because that's what the federal amount is, $11.5 million. But we do ask questions: does someone have any real estate? Do they have other real estate anywhere else? And ballpark amount of what someone has. Because not that people have more than $11.5 million, but you kind of want to have an idea of what people have. And now, there even if someone has a will, there are certain assets that don't pass under the will. So, a common example is a house is owned husband and wife. The deed says, John X and Joanne X, husband and wife, or you used to say his wife, and now it's husband and wife, or married. Well, that means it automatically goes to the surviving spouse. Doesn't even need to have a new deed done. Bank accounts, for example, are by title when it's payable upon death, joint tenancy, POD. Certain assets pass by contract. Those are where you have a beneficiary, IRA, 401k, life insurance, annuity, pension plans, anything that sets forth a beneficiary. So the will can't change that. So it's important that even after we do the will, we tell everyone, get a printout of your policies and who's beneficiary. Who are the beneficiaries? That way, it's going to go into a box or a folder where you're going to keep your important papers. Now we get into the important thing. I'd say, who's going to be the beneficiaries? And it's become more common where, people don't treat all their kids equally or leave their kids out. Not because they might not like their kids, but sometimes the parents say, listen, I'd say, my kids they each have their own house, but I would rather have it to go with my grandkids to pay for them going to college. I'd rather have it for them to pay for, let's say, a wedding in the future, which is a big ticket item. Typically, if most grown children get something, they're going to buy luxury items. They're going to buy a boat. They're going to buy, an expensive car. On the other hand, someone doesn't, you can leave people out. I'd say, at one of the clients said, do I have to leave everything equal to my kids? He goes, no, it's whatever you want. What's your concern? And the lady goes, well, my one son lives in California. We don't hear much from him. So I says, well, did you get a card or a call on your birthday? No. Did you get a card or a call on Christmas? No. Did you get a card or call on your birthday? No. Well, then why should you leave them anything? If they don't care about if you're even alive, and I found by experience, that's going to be usually the person that is the biggest troublemaker when someone dies. It's saying, where's our money? Where's our money? Where's our money? So, it's not like on TV where you leave them $1 or put down reasons. I make no bequest to this person or their children. Sometimes we don't provide for a kid because they don't need the money, and one of the kids may need it more. So we had a client, her daughter was married to Dr. Rosenberg, the plastic surgeon. I'd say, yeah, they had a big giant house in Upper Saddle River and also a big giant house in LBI overlooking the ocean. There are millions. What does this daughter really need $150,000? She's going to go buy a $150,000 ring. One of the daughters, on the other hand, it's like, the husband was unemployed, then they got divorced, and she's just scraping by at her job at ShopRite. Well, she really needed the money more. So, the clause was, listen, I'm leaving more to this one because she needs it more. I love all my children equally. And sometimes someone says, listen, I'm going to leave more to this person because in my time of need, they were there for me. I'd say, but we also have to be concerned with undue influence. If someone comes in and goes, I want to leave everything to most of it to my one daughter because she lives with me, I goes, okay, we can do that, but in case the other one's going to complain and file an objection to the will, when we do documents, when we sit down and meet with people, no one's in the room. When we sign the documents, there's no other family members. We have independent witnesses from our office, and then they sign a certification saying that they were the witness. I'd say now also, we don't want. I mentioned about leaving things to grandkids. We still have a clause that says they don't get the money, and no one gets any money until they're at least 21. The money can be used for health, education, college, important stuff, but not money outright. Because how many 19-year-olds do smart things with money? Zero. I mean, if I would have gotten a chunk of money, I would have got a place down Seaside for the summer and had someone go buy us beers. And the other thing is that when young people get money, they're subject to influences by whoever their friends are, whoever they're dating. So when someone has minor kids, we say, listen, they're going to get a third when they're 22, a third when they're 25, the balance when they're 30. But the trustee can advance as much money as they deem appropriate for college, for buying a condo, buying a townhouse, maybe buying a business, as they deem appropriate. So someone finishes with school, goes, listen, I'd like to buy into this business. If the trustee, deems that's appropriate, can do that. On the other hand, if someone drops out of college when they're 20, goes, hey, listen, Uncle Bob, college is very stressful, and I need to find myself, and I want to take a trip across Europe with, a bunch of my buddies, and I need $200,000, $100,000. Uncle's going to say, go work a harder job. Your parents didn't work hard, so you can go blow it on trips with your buddies. And now, if the guardian, if someone's a minor, or we have what's called a trust in the will, trustees, the person holds the money. If there's minor children, the guardian holds the children. So for people with minor children, I usually ask, okay, if you could, sometimes they have difficulty in thinking who they would want. He goes, oh, it's easy. It's easy for me because I don't know them, but who don't you want? And if you couldn't come home for the next week, if you couldn't leave this room, who would you trust watching your kids for the next week? And sometimes the concern is, well, my parents are getting older. He goes, yeah, everyone's getting older. Now, our concern is there's a lot of this cheap stuff online that people try to cheap out and do stuff for free. Well, I said, You can try to do your own electrical work for free, but if you don't do it right, bad things happen. And, you know, you can try to do your own plumbing work, watching a YouTube video, but if you don't do it right, you're gonna have sewage in the basement, and it's gonna smell, and you gotta throw it, you know, because it's a health hazard, you gotta throw it, everything that touched, your house is burned down, so when people try to do their own documents, a lot of times I say, listen, you're burning down your house. Yeah. So anyway, you wanna have a clause that says it is self-proving. There was a change in the law that said, that the prior law, two people signed, then you had to find one of the two witnesses. There's a new law that says, self-proving, where the person signs, two witnesses sign, the attorney and notary signs, then the person signs again with some language, the two witnesses sign again, the attorney and notary signs again. That way, the will can be admitted to probate without the witnesses coming forward. But the cheap stuff online does not have any of that stuff. Logistically, right now, we prepare the documents, we email it to everyone, we tell them print it out, don't read it online, because we know that when you print something, you read it more. When you're looking at a paper, you read it more thoroughly. When you get stuff, it's like getting an email, yeah, I'm gonna go, you scan it, but I tell people, print it out, because there's no such thing as scanned wills, they're not filed anywhere. You print it out, the original will gotta be signed, and then you keep the original will. You know, it's not kept by any state agency. It is a good idea to let Executor 1 and Executor 2 know where it's at. Most people have their spouse as the Executor number 1, and they buy a fireproof box at Costco, and they put their important papers in it, and they just say to Executor 2 and the family, hey, the important papers are in a fireproof box under the bed. If someone's burglarizing your house, they are not going to steal a box of papers. They want gold, they want money, they want jewelry, and typically they'll just dump the box. They'll throw a sheet on the bed and dump the stuff out, and so don't mix your gold and Krugerrands with them. Okay, so periodically someone comes in and says, I want to get a trust done. I always ask them, why do you think you need a trust? I'd say, were you watching Susie Orman? They say, oh yes. Hey, Susie Orman is exactly correct. If you live in New York, California, Florida, where probate is very, very complicated, you want to have a trust. Okay, but New Jersey, probate merely consists of when the surrogates is open, you're bringing the original will, death certificate, check for $150 to the surrogate. While they're closed, we fill out a form. We fax over the copy of the will, copy of the death certificate, the information sheet, then the surrogate sends us back the forms, then we mail them the original, by certified mail, the original will, an original death certificate, $160, and then there's papers to come back, and someone becomes the executive. Not that complicated. Some people want a revocable trust avoids probate. There's two benefits of a revocable. I tell people, why do you think you need a revocable trust in New Jersey? You're spending, $3,000, $4,000, $5,000, $6,000 on something when a $400 will is just as good for you. But two benefits of a revocable trust. It doesn't have to go through probate. So we looked at last spring when the circuits were physically closed for over a month and a half. Wills couldn't be admitted to probate. And it automatically goes to whoever you pick, but it does not protect anything from taxes. It doesn't protect from Medicaid. What it does protect is when people set up what's called an irrevocable trust. Now, what an irrevocable trust is, let's see, you're not owning the property anymore. The property is retitled, so the house goes into the name of the irrevocable trust. Assets go into the name. If 5 years go by, it's protected from Medicaid, it's protected from creditors, it's protected from taxes because it's not owned by you. A lot of people don't want to spend the money, but for some of the older people, hey, it's a wise investment. Next document we're going to talk about is the power of attorney. Now, what a power of attorney is? A will takes care of your assets if you pass away. The power of attorney is the document that says, okay, listen, I'm giving power to my spouse, one of my kids, etc., that if I become incapacitated, they can make sure my bills are paid, and that someone is looking after my stuff. Nobody plans on becoming incapacitated, but I got clients that fortunately they did it, but then when they had to go into assisted living, it was already in place. Right now, we have a problem with signing documents where someone's in assisted living because I can't go in there. I can't even go into the lobby. I have to wait outside. If I want to drop something off, I put an envelope, I put it in, the vestibule, and then someone with a surgical mask comes out and gets it, and some of the facilities are not doing it. But, so, the power of attorney is a good document because, if someone passes away, hey, there's a law that sets forth who's getting their stuff. And, however, if someone becomes ill, a spouse doesn't have a right to step in and do anything under the law unless there's a power of attorney. So, with the power of attorney, you're giving the power to the spouse or family member to do stuff. And, I remember one time, one of my neighbors in Edison said to me, Kenny, I need a power of attorney so I can sign for my husband at the closing. We're selling a house, moving to Carolina. He goes, okay, fine, when can your husband come in? Well, he can't, he had a stroke. He goes, well, we can't do, is he competent now? No, not really. He goes, well, I can't do a document for someone who's not competent. Is he getting better? I remember talking, it was a rare time where I talked to the doctor. And, the doctor says, Kenny, that's a God question. The person going to get better. But, the client goes, how can I sell the house? We have an offer. I go, you can't. Just because both names are on the deed, because it wasn't a power of attorney, you can't sign. You would have to go through an expensive, complicated guardianship proceeding to have the family member determined incapacitated. It used to be called incompetent, and spending a lot of you have to go through a whole court complaint. You avoid that by having a power of attorney. Now, the power of attorney is effective either right away or only upon disability. So if it's effective right away, that's called the durable power of attorney. Durable meaning it stays in effect if someone becomes disabled and incompetent. A springing power of attorney only springs into effect if someone becomes disabled and then there's a certification by a doctor saying the person is incapacitated under the statute. We had a client though, he goes, Kenny, I'm a carpenter. You're using legal terms on me. Please explain in carpenter terms what this means. He goes, okay, that's easy. If it's effective, and your son's going to be your power of attorney number one. If it's effective right away, your son can steal all your money right away. If it's effective only upon disability, your son needs to get a note from a certification from a doctor before he steals all your money. Knowing that, you trust your son. He goes, I trust my son with my life. Okay, then that's the answer. Now, also beware of cheap forms online. A lot of the banks were giving people a hard time, saying, "Oh, it wasn't done in our Wells Fargo form," and I don't really know. So, New Jersey legislature said, "Listen, if the power of attorney makes reference to Jersey statute, they have to honor it. However, it has to make reference to Section 2 of PL 1991." C95, C46:2B-11, and I'm pretty sure the free stuff online that someone finds doesn't have that. Again, the power of attorney is effective either right away or only upon disability. Most people make it effective right away. After the power of attorney, now, the only time a power of attorney is filed is typically if someone is going to use it to transfer or sell real estate, that it needs to be filed with the county clerk's office. Other than that, it goes into your box. However, it is still a good idea for someone to scan the power of attorney and then email it to yourself, the family members, just so they know who's the captain of the ship, and plus email it to your financial planner, your banker, your accountant, anyone who deals with your finances, life insurance person. This way, they know that there's someone who's authorized to talk for you, because it's better if they have it ahead of time. Because, and then, you know, like if my parents, for example, the financial planner, like, you know, gets the power of attorney, and, you know, calls my dad up just to say, listen, we got an updated power of attorney, is this what you want? Yeah, you know, my son's the guy, okay, that's fine. The last document we're going to talk about is the living will advance directive. So there's so many advances in modern medicine that, you know, hospitals, doctors can keep a body going for long periods of time where there's no hope of someone regaining consciousness. I remember I used to say, well, I couldn't run every day. I wanted to be put down like you do the racehorses, not break their legs. And the very first time I was on crutches, you know, with a cast where I couldn't run, he goes, wait, I don't want to be put down right now. I might still have a couple good years left. But see, I always say the living will is not for you because you're the one that's, you know, basically in a coma in the hospital. It's for your family, so that your family is not put on the spot to say, okay, what should we do? And you know, I remember one time when a doctor asked me for someone who did not have a power of attorney, I mean a living will, advance directive for healthcare, what should we do? Now, I said, geez, doctor, I feel bad. Now, you know the right decision for someone who's 92 years old, that's never gonna walk the planet again, it's never gonna open up their eyes, but you hate to be the one to say, okay, yeah, today's the day, you know, pull the switch. I couldn't even do it on my dog, when my dog was all you know, sick and ill. So, the good thing with the living will advance directive is you're giving, you've already made the call. And you're saying, okay, listen, now, in the living will advance directive, there's a section that says, okay, fluids and nutrition, you're gonna initial either yes or no. Nowadays, probably 90% of the people initial, hey, there's no hope for me. I don't wanna have fluids, nutrition, feeding tubes, etc. Some people are afraid to do stuff because, you know, they think, oh, I'm not sick, I'm not dying. Well, let's say, you know, there was tens of thousands of people that wish they would have had powers of attorney there when they went to the hospital last year. And once you're in the hospital, it's too late to do documents because the hospitals were not, you know, witnessing and notarizing documents when people were that ill. People are also afraid that, well, if I sign a power of attorney, does that mean that, you know, I won't, if I have a heart attack, I won't be resuscitated? He goes, no, it's really dealing with where you're so far along that there's no hope for you. I mean, if someone has a heart attack, if they're like, you know, going to Craig's Deli, they're not going to say, okay, well, just call the undertaker and we're going to leave him there. Hey, the medical professionals are going to do what the best they can to keep the person going, bring him to the hospital, and then otherwise. Now, then the power of attorney has a section asking questions on artificial machines, and 99% of the people initial no. If there's no hope for me, I don't want to be my earth body be kept going through artificial machines. Plus, knowing that the hospitals will send you the bill for the deductible afterwards. You know, the will has an executive 1 and executive 2. The power of attorney is agent 1, agent 2. The living will has number 1 and a number 2. Some people may pick a different person on their living will if someone has more knowledge regarding medicine, but you want to have a number 1 and a number 2. And another important reason for having this document is what we found is that all of a sudden someone's in the hospital and the kid that wasn't involved all of a sudden, comes in from out of state and walks into the room and goes, I'm in charge now. I goes, no, you're not in charge. They did a living will in 2019 in our office in Edison, and the person who picked to be the captain of the ship is this person. It is important in the living will to have what's called a HIPAA clause. A HIPAA clause is, under federal law, the doctors legally can't even talk to a family member unless it's something in writing. So we added a HIPAA authorization in our power of attorney and our living will saying, doctor, you have the authorization to talk to this person, number 1, and, this other person as a number two. We also have a clause like, organization yes, organization no. We recommend everyone initial the box that says yes. I mean, if there's no hope for you, but, and you can save someone's life who's gonna die on Thursday, because they need a kidney or something like that, why bring this, why bring a good kidney, into the earth? The New Jersey, Sharing Network handles organizations, basically for the state of New Jersey. And I attended a full day program to get more knowledge on things, and I asked what is the maximum age for being an organ donor? And they said there is no maximum age. I goes, well, what's good on an 85-year-old guy? And they said skin and cornea. I goes, wow, I never thought about that. If I was burned in a fire, I'd want old guy's skin as opposed to the stuff that burned off me. If I went blind and there was a procedure where they could put old guy cornea in me, I'd rather have that than blind. I also asked the question, what diseases disqualify someone from being an organ donor? Because to be a blood donor, the list of disqualifiers is 11 pages long. They said at the time, the only disqualifier to be an organ donor was HIV positive. And since then, they took that away. Someone can be an organ donor who's HIV positive to donate, a kidney, something else, to someone else that's HIV, positive. If someone's partner is dying and, they need a kidney, they would rather have, their partner, if their partners, both are typically gonna have it. So now the living will, you also want to scan, send that, send email to yourself, email to the family members. That way, if it's an emergency on a weekend, you have it. I'd say, don't put stuff in a safe deposit box. If you need it on a weekend, on a Saturday, on a Sunday, that you can't call the bank on Sunday afternoon, goes, listen, I need to go into my safe deposit box to get out this power of attorney, or living will. You have it there. And every time you go to the hospital, there's a question, do you have a living will, yes or no? Yes, I can email it to you right now, it's right here. Now, I briefly mentioned probate in New Jersey is easy. I mean, we get around, while the surrogate's offices are physically closed to the public, but unlike other states, once someone, when there's a will, the person who's a captainship is called the executor. When there's no will, the person becomes the administrator. So a couple things we assist people, the executives, administrators doing. When there's a will, we have to send a notice of probate to all the beneficiaries. We got to file that with the surrogate's office. We apply for the tax ID number, open up an estate account when there's more than 2 beneficiaries. Then houses are sold, assets are liquidated, put into estate accounts. If it's equal divide, sometimes rather than liquidating things, we just have, like, when there's a financial planner, we say, okay, listen, you're gonna open up 4 separate accounts for each one of these 4 kids, and then they can do with it what they want. Bills are paid. There's a New Jersey inheritance tax. Now, there's no tax that's due if it's going to spouse, children, grandchildren. If it's going to brothers and sisters, the first $25,000 is tax-free. If it's going to charity, bona fide charities, nonprofits, then there's no tax. If it's going to anyone else, there's a 15% tax. We gotta file the inheritance tax, even if there's no tax due, because if there's a house, we gotta get tax waivers. And then after that, the executor typically does an informal accounting, sends it to all the beneficiaries, and then we prepare what's called a release and funding bond, and says, okay, here's your informal accounting, you're getting approximately X amount, please sign and say you're cool with what the executor or the administrator did, so that we can file this with surrogate. And once everyone signs the release or funding bond, We file it with the surrogate, the executor cuts a check to everyone, and the estate's over. Occasionally got one of the beneficiaries that's, what's the legal word, pain in the ass, and they don't sign, because it gotta be signed in front of a notary, properly signed, and they don't do it. And so, we send out to everyone, you know, everyone gotta sign this. We usually wait 3 weeks. If you don't get it in, then we send another letter to all the beneficiaries. Listen, everyone has signed this except for, you know, brother X in upstate New York. And unless brother X signs this properly in front of the notary, that's gonna delay getting your money for half a year, because then we're gonna have to file a complaint order show cause in the Superior Court, prepare a formal accounting, have the surrogate then assess substantial fees against you, and everyone's money is gonna be delayed, and it's all gonna come out of your pocket. Let's see, however, if brother X does it, then we don't have to go through all this. The address, phone number, and email, brother X is this. This way everyone can get on the phone and start harassing that person. We just did that in an estate in Essex County. The person, it wasn't a release or a funding bond, it was the renunciation, but one of the people just didn't sign. So we had all the brothers and sisters setting up, listen, sign the thing so we can move this along and get our money. And so, those are some of the major changes in New Jersey. We're waiting for the surrogates to reopen, but that's it. My name is Ken Vercammen. My office number is 732-572-0500. We are at 2053 Woodbridge Avenue, Edison, New Jersey. So don't be a putter offer. If you haven't done your documents, get them done. Don't wait until you're dead. Don't wait until you're in the hospital. I had two different friends of mine at the Elks Club, and one of them, every time I saw this guy, and we went to high school together, Kenny, my wife and I gotta come in and do a will. We gotta come in and do a will. Well, this guy worked for Morgan Stanley in the World Trade Center. The day after 9/11, my office gets a call, and he goes, hey, it's X, I think I should come and do the will. And I call him back, goes, oh, I'm so glad you got out of the building. You know, it's okay, come in Thursday, we're gonna go over your stuff. Well, he goes, I'm kind of busy. He goes, busy doing what? Terrorists blew up your building, you have nowhere to go. You know, it's before you had a remote. I'll see you Thursday. Another one of my Edson Elks brethren, this went on for like a year and a half. Every time I see this guy, oh yeah, my wife and I gotta come in and do a will. Finally I said, listen, you're not allowed to talk to me ever again, ever, until after you do this, because we've been doing this all along. You don't work full time. Your wife is retired. What are you waiting for? I'm saying, I'll see you Thursday at 11 o'clock. I'm saying, you can almost walk to my office. You live in Edison. Let's get it done. I've never had anyone in 35 years after doing a will say, oh, I wish I didn't do that. It's not like buying the wrong kind of car or something like that. You get it done. Okay, thank you everyone. Get your wills done. Have a good day. Bye-bye.